Good afternoon, everybody. Today, our webinar is going to talk about what it's like to be a trustee, and we're going to take you through being a trustee and through Trustee School and navigating your role with confidence. I'm Paula Clarkson, and I'm one of the partners here at Merhab Robinson and Clarkson. So, um, let's go ahead and just jump right into things. Again, some background on our firm. We do estate planning, trust administration, probate, and asset protection planning, business succession planning, as well as everything for the business owner from incorporation to advising on employment law and mergers and acquisitions. So, today we're going to cover what is the role of a trustee, what notices and things need to be given out, title and ownership, how you marshal the assets, tax implications related to the trust administrations, and dealing with some beneficiaries. We're not going to have an exam, but we're going to kind of wind it up at the end for you. So, a general overview of estate planning or of trust administration is we want to gather all of the estate planning documents that the decedent had, because they're going to be our roadmap and they're basically our playbook telling us what we need to do. So we're looking for the decedent's trust, will, any amendments to the trust, and things like that. There are certain notifications that we're going to give out to creditors, to beneficiaries, and so forth that we're going to go through. We need to marshal all of the decedent's assets and value those assets as of their date of death. We're going to pay all their final bills and expenses. Contrary to popular demand, a person's debts do not die with them. They do need to be paid before they are distributed to their beneficiaries. The trustee will provide an accounting to the beneficiaries showing what is remaining to be distributed and then distribute the assets to everyone. So, as I mentioned, when we're gathering the estate planning documents, we're looking at everything. Trust documents, amendments, did they do a restatement? Is there a will? Is there a codicil is basically an amendment to a will? If they were married, is there a property agreement? Do they have a premarital agreement saying how things are supposed to go? Does their trust align with those property agreements? Are there any other issues that may have come up? It could be a divorce decree. Sometimes when spouses get divorced, one spouse is required to maintain life insurance that would cover perhaps child support or spousal support. We want to make sure that all of those things are in line. And if they aren't, then what do we need to do to take care of those? If a person has an interest in an entity, we want to gather all of the information regarding the legal entity, whether it be articles of incorporation, bylaws, operating agreements, partnership agreements. We need to know what they're allowed to do. Is there a buy-sell agreement in place that their partner is required to buy them out? Are they only allowed to distribute this asset to certain people? Is there a right of first refusal to other parties? So we need to have a general idea of all of that information before we begin. Then we want to look at what does the trustee, what their general role is. Trustees are only one part of the triangle. So when you have a trust, there are three roles. There is the settlor, often referred to as a trustor or grantor. That is the person who created the trust and will always be the same person. Then you have the beneficiary who benefits from the trust. During the person's lifetime, the settlor and the beneficiary are often the same person. They're the ones that benefit. Now that the person has passed away, there are different beneficiaries, whether they be charities, family, friends, and so forth. The trustee is the person who manages the trust. And like we said from the beginning, the person who creates the trust will probably be all three roles. But when they pass away, they will continue to be the settlor, trustor, grantor, but the trustee and beneficiary will change. Now, sometimes people think that if you are in this case, would be a successor trustee to the person who created the plan, that you're not allowed to be a beneficiary. And that's not true. We often do have the person who is a beneficiary also as a trustee. Especially in a case where maybe a parent dies and has three children, names one of their children to be the successor trustee. In that case, they are wearing the trustee hat and they are also the beneficiary. But when we are representing them in that capacity, we are only representing them in their capacity as a trustee, because their rights and their duties as a trustee are very distinct from their rights and their benefits as a beneficiary. So sometimes those rights can be in conflict. So they have to make sure that they are wearing the correct hat when they are making certain decisions. So being a trustee is a fiduciary role. It's the highest standard of care under the law. So the California Probate Code provides that, as the trustee, you have a duty to administer the trust. It means you need to follow the terms of the trust. You don't get to make up your own rules. You don't get to say, well, mom said she really wanted this piece of property to go to this person. That doesn't matter. We have to follow the terms of the trust. You have to be loyal to all of the beneficiaries. And impartial. You cannot pick one beneficiary over another. And that's why it's very important that you're wearing the correct hat. You can't have a conflict of interest. If you have an investment or an interest in something that could be contradictory to your role in administering the trust, you have to avoid that at all cost. Your job is to protect, control, preserve all the property. We don't want it to be wasted. We don't want it to be lost. Generally, there's a prudent investor rule. Nobody's perfect. We can't all time the stock market to, grow or, sell property at the appropriate time. There are fluctuations in the market. It's just what would a prudent investor do at that time, which we're going to go into a little bit more detail next. But you want to keep the trust property always separate from your personal assets. When you're taking title to those assets, you are taking them as title as you as trustee of the trust. You don't pay your personal expenses out of the trust checking account. You don't put your personal money in that trust checking account. If you do, you could be loaning the money. And we want to have proper documentation. Sometimes that's necessary if, we've had clients where the main asset is a piece of real estate and there's not a lot of liquid assets. So one or more of the beneficiaries, maybe the trustee, will loan the trust some money. So there's some liquidity at the beginning. But we want to make sure that that is properly documented as a loan, not just you using the trust as your own bank account. We want to enforce the trust, any claims against it, defend the trust against any claims that could be made against it. Make sure that the beneficiaries are always well informed. And then there's a duty not to delegate your duties. However, you can use professionals or other people to assist you with managing it. But the bottom line is the buck stops with the trustee. As I alluded to, as a trustee, there's a prudent investor rule. That means that you're supposed to manage the asset as any prudent investor with the same information would do in reasonable care. Like I said, nobody's perfect, but we have to make sure that, using this information that you have, what would any other reasonable person, how would they hold those assets? How would they invest them? If there needs to be, when would they be sold appropriately, and so forth. When we're looking at the decedent's estate planning documents, some of the very important provisions that we're going to look at are going to be what law governs the trust. Obviously all the trusts that we create are governed under California law because we are located in California, licensed in California. But sometimes we will have a decedent that perhaps moved from a different state and did not update their trust. So if there is any question, if there is a discrepancy in the trust or anything like that, we're going to have to look to the law of the trust to clarify those things. We're going to look at who the trustees are, the successor trustees are, and so forth. Who are the beneficiaries? Are there specific gifts? do they get a percentage? Do they get a dollar amount? Does the beneficiary get, how do they get it? Do they get it outright? Do they get it only upon attaining certain ages? These are all very important to follow the rules. What does the trust say about accounting? There are still trusts out there that I see that waive the right to for the trustee to give an accounting, but that is against the California law. So the trustee is required to give a proper accounting to the beneficiaries. The beneficiaries can choose to waive that right to an accounting, or a lot of times we will work with the beneficiaries to provide the information that would be in an accounting, but not give them the exact accounting. So they have all the information. They can make sure that the trustee has done what they're supposed to do, paid the appropriate bills, and that they're not stealing the money, basically. And then we always want to look at what the trustee's compensation is. The trust will generally say what the compensation to the trustee is. The California Probate Code says a reasonable compensation, and that can vary greatly. If you have, someone who's maybe been in assisted living and they only have liquid assets, maybe an investment account and checking account, that is a lot easier to administer than someone that maybe has a business, has multiple properties or the trustee has to sell it. There could be a lot of work, or if there is lawsuits that the decedent was in. So we usually encourage our trustees to keep track of all of their time that they're spending administering the trust. So that if there is ever a question of what did they do and if their compensation was in line and reasonable with what they did, then we can justify it. Because the beneficiaries who are not involved with the administration often thinks that it's a lot easier to do than it is. And it's funny, we usually have at the beginning of, I would say, almost every trust administration, the trustee says, "Oh, I'm not going to take the compensation, I'm going to waive it." And we always say, wait, wait, wait. And then when we get down to the end of the administration, they're like, "Oh, yeah, that took me a lot of time." Because sometimes it could end up being a second job, depending on how big the administration is. So we never want to discount that. Now, the trustee doesn't have to take all their compensation, they can take a portion of it. It is considered personal income to them. So in some cases, we're dealing with income tax on it versus if they took it as part of their share as a beneficiary, then they're not receiving, entitled to income tax on it. So we want to look at all those different avenues. So the next thing that the trustee needs to look at is notifications. So there are a lot of notices that we need to give when someone passes away. So there are deadlines. So the biggest notice that we always want to get out as soon as possible is a notification to all of the beneficiaries and heirs. So this is something that needs to be done within 60 days of the person dying. And the probate code has a section that says anybody that is an heir, meaning like a child, a descendant of the decedent, or is named in the trust as a beneficiary, is entitled to a full copy of the trust. And we send out the notification with a copy of the trust, and then it starts a time period that the beneficiary has and heirs have 120 days to contest the trust. So those are really good notices to get out right away. And it's important, sometimes I'll get the question of, well, can I just give the beneficiary just the page that shows what they're entitled to because I don't want them to see what other people are getting. And we can't do that because they're entitled to know what is the full trust, what is everything related to this to make sure that they are getting their correct share of the trust. We also have to give notices to government agencies. There are things like the Department of Healthcare Services in California, if someone is receiving Medicare. If someone, there could be, if one of the beneficiaries is in prison, there we might have to give notice to the Victims' Compensation Board because any inheritance that person receives may be required to be paid to victims of that person's crime. and things like that. So it really just depends on the situations. Taxing authorities, we always want to give notice to the franchise tax board to make sure that the taxes are all up to date. And if there is we don't necessarily give a notice, but there could be an estate tax return that needs to be filed, which is a form of a notice that is due 9 months after the person passes. We also give certain notices to reporting agencies. Some of the biggest things are to the credit card companies. We like to give them notice so that they can put a block on the decedent's credit cards so that nobody is opening new accounts after they've passed away because of identity theft or trying to take advantage of them, and so that they can close them down and go forward on that so that there isn't anybody using their identity forward. As I mentioned, that the notice to the beneficiaries and heirs can come in two different ways. If you are become a trustee because someone has become incapacitated, maybe your parent has got dementia or Alzheimer's, then we will give notice under probate code section 15800, letting them know that the trust is now irrevocable. We have a new trustee, but this is due to incapacity. And then when the person passes away, the notice is under 16061.7. And as I mentioned, we like to send a copy of the trust at the beginning with it because the person has then 120 days to contest the trust. So it brings to the forefront if there's going to be any issues from any beneficiaries. If we do not send a copy of the trust with it, then when the person requests a copy of the trust, then they get an additional 60 days. So I like to just cut off that extra 60 days and take care of it from the beginning, because also, as trustee, you are supposed to be acting impartial and treating all the beneficiaries the same with the utmost forthcoming. You're supposed to be responsible to them. So giving them all the information from the beginning shows that you're being transparent. Once you start hiding things, they think that you're doing something wrong, and then they start questioning everything, and it can cause lots of problems. Another notice to consider when someone passes away is if we give notice to the creditors. So in a probate, we are required to give notice to creditors within a specific period of time, and then the creditors have a period to respond. In trust, we are not required to give notice to the creditors. And in some cases, we like to let the statute of limitations run. So when someone passes away, there is a 1-year statute of limitations for them to make a claim against the estate. So, like I said, it can be shortened either by probate or potentially by a sending notice. Sometimes people like to force the issue because they just want to be done with it and not worry about it. But in other cases, we sit and keep the administration open on purpose because we may not want to tell the creditor that the person's passed away and allow that statute of limitations to run. Conversely, there could be claims by the decedent's estate. So if the person was involved in maybe a wrongful death or medical malpractice, or there was some contract issues, there's a time period in which the decedent's estate can bring those actions. So depending on the circumstances, there are various different statute of limitations. You always want to make sure that none of those types of claims, either brought against the estate or by the estate, are blown. The next biggest part of administering the estate is title and ownership to the assets. And this is the hardest thing. So the trustee needs to marshal the assets. They need to secure them. When a person passes away, the trust becomes irrevocable. We will get the new tax ID number because we can no longer use the decedent's social security number. So using the tax ID number, we create what's called a certificate of trust. It's basically a shortened version of the trust that the trustee will take to financial institutions to marshal those assets. So usually they will go, like if the decedent had a bank account, they will take the certificate of trust to the bank. let them know with the death certificate, the certificate of trust that the person has passed away, and then ask to open a new account. So we can no longer continue to use the decedent's account because it's using their social security number. So the trustee can open new accounts at that institution. They can change institutions if they like. Often it's a great time if the person had multiple checking and savings accounts to maybe consolidate those, or if they had multiple investment accounts and things like that. If a person has, an investment account at, a brokerage firm, generally what they'll do is just open a new account at the brokerage firm, move those assets over as they are, and then the trustee can then choose to move it to a different investment firm or decide what they need to do if they need to liquidate anything, and so forth based on the administration parameters. So so literally the trustee has to go through every single asset that the trust or the decedent owns. And we keep track of it in a spreadsheet. It's just much easier. Going through, okay, the house, let's pull up title on the house. Is it titled in the name of the trust? Great. Then we have a document to put it in the trustee's name. We record it. We're going to get a valuation on it, like an appraisal, or the trustee's going to sell it. If we sell the asset within 6 months of death, we can use the sale value as the date of death value. So we want to value everything. It's kind of like a snapshot. Here's the value of everything on the decedent's date of death. If we pick today's April 15th, everything that the decedent owned, the value of the house, the value of the checking account, savings account, investment account, Roth, business, whatever they own, we need to know how title was today and what the value of that asset was today, including any debt. There could be a mortgage on it, or if there's promissory notes or anything like that. What is the value as of the date of death? That is what we're looking for. And those values are very important for multiple reasons. They're one, so that we can help divide the estate depending on, if it's divided 3 ways, we need to know how to divide it 3 ways based on the total. We also get a basis adjustment in the assets. Okay. And it's generally a basis adjustment up. And so, for example, when people buy their houses, that is considered the purchase price of something is your basis. So if, we have a lot of families in Orange County that may have bought their house for $100,000 30 years ago. That is their basis, plus any improvements that they've made on the home. And then when they pass away, we'll get that property evaluated. And if the valuation comes back and it's, say, $1 million, that is their new cost basis. It gets adjusted to the date of death value. And the benefit of that is because if they had sold the property during their lifetime, the decedent, then they would have capital gains from the sale price to their cost basis. And that could generate a lot of taxes. But when someone dies with a basis adjustment, then in this example, with the house now being valued at $1 million, if it's sold in the future, we look at the sales price minus the value on the date of death. So that has eliminated, in my example, almost $900,000 that would be subject to capital gains tax. So in most cases, we are looking at an adjustment up. But there have been years around, especially around like 2008, where property values have gone down and there has actually been an adjustment down. So that's always really important to look at on what we're doing. So that will help us set things. It will also, if the property is going to be kept, if it's something like a rental property, then it will reset the depreciation that is allowed to be taken on that property that can help the beneficiaries in the future on their income taxes. So also looking at title is very important. Is the asset in the trust? Is the asset an asset that is held in joint tenancy, meaning 2 people own the property and that the survivor of the 2 gets that property? So we see that a lot with bank accounts, sometimes with real estate. Then we have to look, is there a beneficiary on the account? The most common types of accounts with that are going to be retirement accounts and life insurance. Is the trust the beneficiary? Is an individual the beneficiary? Is a charity the beneficiary? All of that will determine how the account is administered. And if you have, for example, a decedent that has bank accounts, investment accounts, real estate that's in the trust, all those assets are going to follow the terms of the trust. If they have an asset like a retirement account, IRA that is outside the trust, the IRA will be distributed according to the terms of the beneficiary designation. And they may be different than the terms of the trust. Sometimes that's intentional, sometimes it's not. So it's very important to look at all the assets when you're planning to make sure that they are cohesive and they do exactly what you want. Now, there are times that we will find that a decedent will have an account in their own name. So in California, we do not have to go through probate until the assets exceed $208,500 and do not pass automatically. When I say pass automatically, that means if they're in a trust, that's the transfer mechanism. If they have specified joint tenancy or community property, payable on death, or a beneficiary designation, those transfer automatically. But if you have a decedent, let's say that they have a bank account in their name for $20,000 with just their name on it. It's not held in the trust, there's no co-owner, and it does not have a payable on death beneficiary. Those are the assets we're looking at. And we're going to add up all of those assets. If they exceed the 208,500, all of those assets are subject to probate. Not the assets that have beneficiary designations or are held in a trust. Those are separate, but just what is in the person's name. Oftentimes, people will keep just their everyday car. Sometimes people will keep just their everyday checking account in their name and keep a very low balance. It's money in and money out type of thing for their bills every month. In those cases, it's very easy. And in California, we call it a small estate affidavit. The trustee just has to wait 40 days. They're able to provide this affidavit to, let's say, the financial institution. They're able to collect that asset. Generally, if a person has a trust, they have what's called a pour over will, which will then allow them to just put those assets into the trust without going through a formal probate. But we do have sometimes where people, we have it a lot where people will take like husband and wives, like one of them will go and open an account online and an online investment account or move it over to a CD or something that has a high yield. And they don't think about it when they open the account and they'll just put it in their name. And if they pass away and the total value of that account is say 250,000, 300,000, we're above our small estate limit. So that one asset would be subject to probate. So that's where when someone has a comprehensive estate plan and with a trust, they could still be subject to probate because they have not either titled things appropriately in their trust, we call it trust funding, or they haven't named a proper beneficiary on there. So those are all part of the pre-planning process to make sure that there isn't any issues during the administration after you're gone. Now, there's another fail-safe. At the back of almost all trust, there's usually a schedule that says these are the assets we intend to put in the trust. In California, there's case law that says if an asset is on there, but it's not titled in the trust when the person dies, there's a procedure that we can petition the court and get that asset put in the trust. It's not a full probate at all, much quicker, much less expensive, but it'll put the asset in the trust. It is unfortunate when we have to do that sometimes, but it definitely is better than going through a full probate. So when we're looking at marshaling the people's assets, it's literally everything they own. Personal property, such as clothing, furniture, jewelry, even their sofas, things like this. Vehicles, what is in their name, bank accounts, checking, savings, money market CDs, their investment accounts, all their real estate, businesses that they own, memberships, timeshares, those types of things, life insurance, any assets that are also outside of the estate, and any assets that they may have outside of the United States. So when a person passes away, we'll go into this in the next section a little bit further. We're talking about, we have to determine how much is the value of their estate to determine if estate taxes are due. The United States looks to your worldwide assets to determine if an estate tax is due. So it's very important that we're looking at everything. Now, foreign assets may pass a different way because not all jurisdictions will accept a United States trust or even understand that it's there. But and they may have their own rules over there, but we still need to figure out what all the assets are so that we can account for them. So taxes, this is the big elephant in the room when someone passes away and what we need to do. So depending on what year the person passed, we need to look and see if there is an estate tax due. So currently, if anybody passes in the year 2026, they can pass $15 million estate tax free. If an individual dies and their estate exceeds 15 million, generally everything above that will be taxed at 40%. And the trustee's job is to file an estate tax return within 9 months of the decedent's death. And the estate tax return is going to have to detail title and value of all of the decedent's assets. We will also be able to list on there all the expenses of the administration, such as the cost of those appraisals, maybe any debts that the decedent had. Did they owe any credit cards? Did they have any final medical bills, funeral expenses, and things like that? All of that is taken into consideration to determine if there is an estate tax due. If a person has, let's say, an $18 million estate, but they have a $4 million mortgage on their property, which when you look at it brings their net estate down to 14 million. That means that their net estate is not subject to estate tax because we've gotten below the limit. However, if their gross estate, the 18 million, is above our threshold of 15, there is the filing requirement. So the first part is there a requirement to file? Then the second part is there going to be estate tax based on the debts of the estate and the administrative expenses? So that's why it's very important that if you are a trustee, that you take control of the assets and value them as soon as possible, because that 9-month deadline comes up very, very quick. And if there is estate tax due, it is due at that 9-month mark. Otherwise, interest and penalties can start accruing. And sometimes that will necessitate the need to sell a property or liquidate another asset in the trust in order to pay that. Now, that filing requirement can be extended another 6 months, but the payments are not. So if you don't pay all of it on time, there is going to be interest and penalties, and that is a no-no for the trustee because they should have taken control, managed the estate, and taken care of those things as soon as possible. So as I mentioned, the big income tax component is the basis. So here's an illustration that I discussed before with if you purchase a home for 100,000, it's currently worth $1 million. The basis would get adjusted up to $1 million, eliminating that $900,000 capital gain. So generally, if the property is sold within the first 6 months of someone passing, usually end up with a loss on the sale of the property after taking in all the selling expenses and the realtor cost. So that can be a huge benefit to the family. And all the assets that get a basis adjustment are basically everything except for retirement plans. So nothing in the IRAs or 401ks or Roths are going to get a basis adjustment because those have a completely different tax structure. But if you own a home, if you have stock, if you own a business, those types of things will get the basis adjustment. So that can be extremely helpful. And that helps when we're looking, even pre-death planning of if mom's going into the assisted living and, in her house is set like this with $100,000 basis and a fair market value of $1 million, do we want to sell that house before mom dies and incur the capital gains, or is it something that we're able to hold on to and sell after she dies? So those are all considerations for the children or other beneficiaries to consider. We'll have sometimes kids that will advance the trust, loan the trust money, so that because the savings of that capital gains tax could be extreme, by not having to pay that and maybe advance it and then get a reimbursement from the trust after the parents pass away. So those are always things to think about before someone passes. Property tax is another huge issue to consider when someone passes away. So, property tax in California is generally based on the purchase price of the house. Now, it can go up to 2% every year. That's under Prop 13. So, that's a huge benefit that Californians have, that our property is not reassessed every year to the fair market value. So, that's why we will have people that, maybe bought a house for $100,000, 30 years ago, that are only paying property taxes at maybe $150,000 limit, because it's only been able to go up a little bit every year. However, when someone passes away, that's considered a change in ownership. So a parent, it dies and transfers their house to their child. That is a transfer and a change in ownership that is going to trigger property tax change. And generally I would say in most instances, the property tax is going to change, and the new property tax on that piece of real estate is going to be based on the fair market value at the person's date of death. Now, there are exclusions. If a person dies and leaves their property to their spouse, the property does not change. So they want spouses to be able to continue living in the property and everything. The property tax then would increase when the second spouse dies and that property is passed on to the child. There are limitations on if a parent transfers their personal residence to their child at their death. It has to be their personal residence, and there's a formula for how to determine the amount of property tax increase. So if the person is paying property taxes, let's say at $100,000 limit rate, the parents when they die, and then let's say mom dies and the property is going to go to her son, then the son would, one, have to move in and make that their personal residence within a year of the parents passing. So they can't keep it as a rental property and keep the value, the property tax. They have to make it their personal residence. And then the formula says, okay, we're going to take that $100,000 that the parents were paying property taxes on it. We're going to add $1 million onto it. So if the fair market value of the property is less than $1,100,000, the property tax will stay the same for the child. And that is great. And then it will just continue to increase at that 2% cap from Prop 13 every year. But if the property, let's say the fair market value was 1.5 million, then we look at it and we go, okay, 1.1 of that property is taxed at 100,000. The additional difference is 400,000, and the child would pay property tax at a $500,000 rate, the 100,000 from the prior part and 400,000 from the excess. Still a increase in property tax, but definitely they're not paying it at the $1.5 million property tax rate if they were to purchase the home. So there is a certain amount of benefit. So what is eliminated from that is if the parents had a rental property, if they own a commercial building, those types of things are kept out of it. There are some exceptions if the property was owned in an LLC. If you have an LLC, up to 50% of the original owners can be transferred to new owners without the property tax incurring. But that becomes, going back and looking at who are the original owners of the LLC and a big formula. So if there are any questions on that specifically, we would have to go back and detail that. But these are always big decisions then on whether the children are intending to keep that property. Maybe one, because they're not going to be able to move into the house and make it their personal residence, or they don't want to, and things like that. And sometimes it's just not feasible because the amount of property tax increase on it, that the children just aren't able to continue to hold it. So always important things to consider, and those are discussions that the trustee will need to have with the beneficiaries on figuring out, do the kids want to keep the house? Does one kid want to take part of the house as part of their share? Then without even adding complications of, you know, if you had, is the value of the house less than that child's share? Then that makes it a little bit easier for them to take it. But if the value of the house is more than that child's share, they may have to buy out the additional difference, and there becomes complications. So those are all things that the trustee is going to need to work around, which leads us into our next section, dealing with beneficiaries and how we handle them. So, you know, who do we have the duty to? Are we accounting to them? Keeping them informed is a part of your fiduciary duty. So I find that it's better to be upfront with them, keep them informed, because generally the beneficiaries don't understand the 9-month deadline for the taxes. That if you have a full-time job, that it takes time to marshal other people's assets, to go to the banks, to deal with sales. So you're often doing that at night and on the weekends. So it's very unusual to be able to close a trust administration within a couple months after someone dies. We have been able to successfully do it. Generally, we don't like to do it within the first 120 days. So we say the 4 month, because as I mentioned at the beginning, we want to give that notification to the heirs and the beneficiaries to contest the trust. So we really want to wait for that 120 days, the 4 months, to expire before we're fully distributing everything, because we don't want some beneficiary to come back at the end, contest the trust, and as trustee, you have no money then to defend the trust and the terms of it. So a quick administration, I would say, is 4 months. Generally, we can get them done within 6 to 9 months. I think it usually depends on the makeup of assets. If a probate, is required because an asset was not properly funded into the trust or with the beneficiary, there could be lingering things. So it all depends. Um, Also, when we're giving accountings, is there problems with the beneficiary? We've had some where the trustee will need to seek court approval of the accounting and approval of all their actions that they took during the trust administration, because there's a problem beneficiary and they will not sign off on it. But I would say for the most part, we have accountings that we will either give in a formal format in accordance with the probate code. We have a lot of accountings that we will just say, okay, and again, it's up to the beneficiary on what they're willing to accept. Here's the closing statement on all the real estate. Here's a copy of the bank statement from the date of death on, so that they can see that the trustee was doing what they were supposed to do. And informal accounting, I think, saves a lot of money for the trust, because it just eliminates the attorneys or the CPAs from putting it in a pretty format, because all the information is still there. But in some cases, it is just a necessary thing. Or sometimes we'll have clients that are really good with Excel or QuickBooks or something, and they'll put it in where it's not necessarily the format that the probate code is requiring, but it's a readable format, and the beneficiaries are getting all the information, and then they sign off on an informal accounting. And there are instances too where the beneficiaries will waive an accounting, that they completely trust the other person and they don't need to see any of the documents. Our job is to protect the trustee and make sure that they are doing their job right, and so that they don't leave anything open to have a beneficiary come after them and sue them. And then also looking at all the statute of limitations that we talked about. Um, Trustees, sometimes we have problems with beneficiaries that are going to either complain about everything, regardless of what the trust says. Or sometimes the trust get written in a way that it's a little confusing. Like it might say that, child one gets X property, but the parents don't own X property when they die. They own Y property. But did they mean that? Did they not mean it? So in some instances, we may need to go to court and do what's called a petition for instructions to ask the court to clarify that. And in those cases, the trustee, again, has to be impartial. They throw it out there. They say, this is what this is the issue that we're having. Court, please confirm it. Oftentimes, we like to have discussions with the beneficiaries ahead of time. If all the beneficiaries are in agreement that, yes, this is what was intended and what was meant, we would love to attach consents to our petition that everybody's on the same page. But if the beneficiaries are not on the same page, it's a forum for the trustee to throw it out there, let the beneficiaries each bring their differing points of view, and let the court rule on it. Also, the approval of the accounting, as I mentioned, sometimes beneficiaries will not sign off on the accounting and will just seek court approval to make sure that the trustee has been confirmed to have done everything that they need to do. We have sometimes when we have real estate sales or even abandoning property, the trustee may choose to do what's called a notice of proposed action. So, for example, if a property is going to be transferred to one beneficiary, or we might do a notice of proposed action saying the trustee intends to sell this property or transfer it to this beneficiary at X value. Everybody else has 45 days, the other beneficiaries, to sign off on that or to object. Or we've had sometimes where there might be, let's say, a timeshare or a piece of raw land out in the desert that no one wants and that cannot be sold. Or even a claim against someone that it's not worth pursuing. It could cost more money to go after it, and they prefer just to abandon it. And the trustee then could throw out there, we do a notice of proposed action that says at the end of this 45 days, the trustee plans on abandoning this claim against XYZ because they feel that it would cost more money to go after them than would be collected. And that way it gives the beneficiaries the opportunity to say, no, I really do want you to go after them, or I don't want you to do that action. And it's a way to kind of get the consent. Or in some cases, just if everybody is in agreement from the beginning, we can avoid that time period. And, like if everybody says, yeah, we're abandoning that piece of property out in the desert, we're never going to be able to go after it. It's not worth it. Then everybody could sign off on it and we can move along faster for the administration. After all the bills have been paid, all the tax returns, that is one of the things, the trustee marshals the assets, they pay the final bills, credit cards, medical bills, funeral expenses, all the expenses of the administration. They have the decedent's final personal tax return, and the trust may have an income tax return for the period that it's open during the administration. Once that's done, then the trustee could be ready for distributions. So we need, again, to go back to the terms of the trust and say, are the distributions outright to the beneficiary, meaning that the trustee, for example, writes them a check, or maybe transfers stock in kind or transfers real estate directly to the beneficiary in their name alone, and it's out of the purview of the trust. Or do the terms of the trust say that, for child one, that those assets are going to remain in trust? And that often means that we're creating what we call a sub-trust. It would be, like if it was the Smith family trust, then we have the Smith family trust for the benefit of child one. And we transfer the assets from the parent's trust into this sub-trust that is solely for that child to be administered under whatever terms the sub-trust provides for. And again, all that information would be in the parent's trust to say, does my child get $5,000 a month? Right, we're going to follow that. Or do they get, a certain amount at certain ages? We're just going to follow those terms. So there could be some different changes. The benefit of having a trust is sometimes we're able to do preliminary distributions. Where in a probate, the executor on the probate cannot make any distributions, cannot use any of the probate money for the beneficiaries until the probate is completely finished and the court signs off on it. But in a trust, the trustee has more flexibility. So once the trustee starts marshaling the assets, if they determine that there are substantially more assets than there are liabilities, at any point the trustee can choose to make a preliminary distribution. They may, make some, at the beginning, they may do some 6 months in, as opposed to doing everything at the end. The comment that we always want to do is make sure that they have enough assets to and remaining in the trust to pay those final bills, or else the trustee's going to be in big trouble because they're going to be liable for it. So usually we're able, at the end, we're able to do the accounting, determine how much is to be divided between each person, including any potential preliminary distributions. And then there's usually still a final income tax return to be um, filed for the trust. So we usually have the trustee do a holdback, a reserve, and the amount depends on the situation. So if we've already passed the 1 year mark, it might just be a small holdback, like $10,000 to do the final income tax return. If we have filed an estate tax return, the IRS, and there's tax due, the IRS has 3 years in which to audit that. So in that case, the trustee may want to hold back a bit more, because if that estate tax return is audited and the IRS comes back to the trustee and says, oh, that valuation was wrong, you owe us an additional $50,000, the trustee better have that, because it's going to be very, very difficult for them to go after those beneficiaries to get that money back. Because I always assume that once you've distributed money outright to the beneficiaries, that they have spent it. And even though we do a receipt and refunding agreement where the beneficiary promises to give back the amount if it's determined for their creditors or in the future, I'm going to always assume that they are just not going to have the ability to do that. So we want to always make sure that the trustee is covered just in case, and never to over distribute until we are guaranteed that there are no further creditors. I'd say another big area that we have is property tax supplemental bills. So when a parent passes away, if, let's say that the children choose not to take the house and, 4 months later, the house is sold. From the date of death until the property is sold, the property tax is going to be reassessed at that current fair market value, and the assessor's office is going to send the trustee a supplemental property tax bill. Unfortunately, often that takes, 9 months. Sometimes we've seen it a year, year and a half. And the rest of the administration could be completely done, and the trustee is still waiting for that final bill. So that would be another reason we need to hold back money, because we know that there are some bills coming down the road. And we never want the trustee to be caught short-sighted. So as we talked about, the main reason, the overview of the trust is, what does a trustee need to do? We need to get, their duty of impartiality to all the beneficiaries. They have to give certain notices, marshal the assets, confirm title, valuation, pay the final taxes that are dealt with, and deal with the beneficiary situation and how they all interact and making sure that everybody's happy and has all the information that they're entitled to. Now, sometimes there are problems, and we want to avoid those as much as possible. So this is where the pre-planning comes involved. We want to make sure that there are not conflicting estate planning documents. This is very, very important. If you want to have a smooth administration after you pass away, make sure that your documents do not conflict. We have clients that will do amendments and legally through an attorney, and then they may just do a handwritten one, or they will write on the documents. Those cause conflict. Do it correctly and do it in order so that they can be very clear on what you mean. We have the old trust. We see that a lot of times people when you have a trust, you can amend it and restate it as many times as you want. But sometimes we'll have, the parents, well, we created this trust in 1990 and it's the Smith family trust, but we decided to make a change. So we just abandoned that. And now we have the Smith trust. And we have to make sure that like what is in place, ideally you wouldn't have done that. You would have just done an amendment of the Smith Family Trust, or you revoke the old trust. This is very important when people get divorced. So making sure that if you are changing the name of the trust or different things like that, that the other one is revoked completely. Is dealing with your separate property, your community property. How is it done? How is title so that there aren't any problems? Do you still have the correct trustee, or do you no longer like that person, or have they passed away? Or as I mentioned earlier, you name and you leave a piece of real estate to one child and you no longer own that piece of real estate. Those are really important things to continue to look at and clarify why you're still alive. When someone passes away, the trustee, failing to maintain the list of assets or is I mean, these are big issues. We need the trustees to know what they're administering. So the clearer that you are and keeping things as, whether you have your own list or it's all in one place is very important. Making sure that before you pass away, you properly fund the trust or name beneficiaries on things that will avoid those little ancillary probates that we have or potentially assets going to the wrong person. So it's always important. Generally everything goes in the trust except for retirement plans, which is IRAs, Roths, 401ks. Those will have beneficiaries. The beneficiary can be the trust, or the beneficiary can be individuals, charities, and things like that. The choice depends on your goals. There's other tax issues, but otherwise you should think of real estate, business interests, all financial accounts, but those retirement plans, personal property collections should all be in the name of the trust. When you have a trust administration, the biggest areas that we see problems are, do the trustees get along? Please never name co-trustees just because they're your two children. They have to get along, or else all of your money is just going to be wasted with legal fees. So if you can't choose one versus the other, then maybe pick an independent third party. There are professional trustees that do this for a living. There are corporate trustees that do that. It will save your family so much money and maybe even maintain the familial relationships. So, and you don't have to pick your trustees on birth order. You don't have to pick, well, child one has to be the trustee, child two is the second one. If child one is not good with money, or maybe they're in a position that they don't have the time, name child two. You want to name someone who is going to follow the terms and do their job as the trustee. And make sure you have a trustee that does not do self-dealing, that they aren't looking at it from their best point of view and trying to screw over their siblings or other beneficiaries. As we mentioned, it's a fiduciary duty and they need to do what is best for all of the beneficiaries, not just for one or two of them. The problems we see, a lot with beneficiaries are failure to keep them informed. Again, not telling them what's going on makes them suspicious and think you're doing something wrong. So it's always a good idea, to say, this is what we're doing. I have some trustees that send out monthly updates. Sometimes we will do the updates for them. It just depends on the situation. Again, don't favor one beneficiary or the other. If you're making preliminary distributions, it should be pro rata across the board, not to one person and not to the others, unless we get written consent from the others that they're comfortable with it. Like I said, keeping your trustee beneficiary hats separate is huge. Marshaling the assets, making sure that we're keeping those deadlines. We have the estate tax deadlines, the biggest thing. The certain notices are the biggest thing. Are you just choosing because you don't like investments that you just liquidate the whole thing and want to distribute cash? That may not be a prudent investment. You need to, I'm in favor generally of listening to your investment advisor or transferring the stock in kind, and the beneficiary can choose to liquidate it if they want to. I don't want them to blame you because you liquidated it and the next day the stock split and it doubled in value. Making sure the expenses are proper, that the trustee is not using the trust money to go on vacation, or to, oh, I needed a new printer to act as a trustee, so the trust bought it, and things like that. Are they proper expenses and things? Hitting those tax deadlines and holding the reserve, as we talked about, are some of the biggest things. So to be successful and make your administration as clean as possible for your beneficiaries is taking a look at the plan every couple years, making sure the right people are there, making sure your trust is funded. If you're married, do you have a proper marital agreement? Does it reflect your prenup, or is it all community property? Make sure that the information is in the same one place so that your successor trustees can figure out what you own and how to take control of it. It often is a good idea if you're getting older that maybe you start talking to your successor trustee, maybe even making them a co-trustee in the last few years of your life so that that transition is nice and smooth. As we mentioned, funding the trust, making sure your assets are in the trust, avoiding probate as much as possible, selecting the trustee that's going to follow your rules, not go off on their own, and seeking proper legal, financial, tax counsel. We have lots of people that will do an administration, or they start doing it and then the beneficiaries will call because the trustee's just not sharing information. They're not doing it right. So they may mean well and they just don't know what they don't know. So although you are having to pay for the advice, often it is less expensive because you can do it correctly and get through it faster. So, our goal is to protect the trustee, to make sure that they're following the trust. We cannot, if a trustee steals money, we can't control that. We tell them not to, but, our job is to make sure that as a trustee, you do not get sued, that you're following all the federal, the state, the county, all the requirements, following the terms of the trust, that, we're reducing your liability, eliminating it by getting beneficiary designations and things, and that you're, we want, when the parent dies, that the beneficiaries can still get along. That's a huge thing. You don't, we see too many families that fight over the money or fight because there's confusion, and a lot of that can be eliminated. It'd be great if your children continue to have relationships with each other, and that the distrust isn't born just because of the administration, by being forthcoming. And sometimes that's even being forthcoming during your plan and explaining to maybe one child why they might not be getting the same as another one, or they might not be getting the same asset, because there's a lot of emotions that happen after someone loses their parent or other loved one. So that concludes our presentation. There is a lot to do as a trustee. We want to make sure that you're doing everything appropriately. And I would open it up now if there are any questions. If not, we're always happy to have you email us, and we can answer your questions in private if you don't want to share them in this forum. At this point, I know there's a lot of information, so it's understandable that there is not a lot of questions at this point. But our next webinar is going to be on Wednesday, May 12th at 12 p.m. again, on May 20th at 12 p.m. And we're going to talk about planning for the different milestones in your life, such as birth of children, getting married, divorce, retirement, and the different things that you should be considering at your different stages. Because as you remember, your estate plan is not a one and done thing. It's going to change and with you as your life progresses and the changes happen in your life. So thank you for attending. We will send out a copy to everyone that has attended, or those that had to drop off, but we appreciate all of your time, and we look forward to talking to you soon and seeing you. Thank you.